Hello, everyone, and welcome to Relic Law's Interview with an Expert series. I'm William Orlowitz, Principal Attorney at Relic Law. Today, we have the pleasure of speaking with Jane Murphy, Founder and Chair of EDPO, who will be taking our questions on local representatives under Article 27 of the EU GDPR. So, Jane, let's jump right in. Can you give us a little bit of background about yourself?
Hi, William. Well, thank you very much, first of all, for having me on this interview. I'm very, very happy to be here to explain a little bit what the EU rep is all about, because it's kind of like this forgotten obligation. Jane Murphy, and I'm a Canadian lawyer and a Belgian lawyer. So I was born and raised in Canada, and I moved to Belgium about 26 years ago, where I qualified as a Belgian lawyer over here, and then did European and international law. And so I'm the founder and chair of EDPO, the European Data Protection Office. And I also sit on boards of listed and non-listed companies in Belgium, so in Brussels, in Paris, in Mumbai, Amsterdam, and Singapore. So I see GDPR from a lawyer's perspective, from a representative's perspective, and also from a board member's perspective, which is also very challenging. So thank you so much, and I'm looking forward to all your questions.
Outstanding. No, you definitely have a great background for this, and I think your insights will be very helpful to a lot of people who are just trying to figure out this subject for the first time. So let's go ahead and jump into the first question here, which is, can you just basically tell us what a local representative is under Article 27? A lot of people don't know or aren't aware of that obligation.
Indeed. So Article 27 provides for the appointment of an EU rep for non-EU companies. So it's specific to companies outside of Europe in the EEA area, so the European Economic Area. So it does not apply to companies in Europe. And it's basically a representative that's there to be kind of like the go-between, between the companies outside of Europe and the data subjects and data protection authorities in Europe. It's basically to make life easier for people in Europe to contact the non-EU companies with respect to the types of processing of personal data that's performed by the companies outside of Europe. That's pretty much it in a nutshell.
Yeah, no, and I think that's an important clarification, because I think a lot of at least businesses and clients that we work in the U.S. Don't realize that, even if they understand that they have to be GDPR compliant, they don't realize that they need to have sort of a representative in the region in order to be their sort of point of contact there. And so I think that's an important clarification, which I think kind of also segues us into section question. Go ahead. I'm sorry.
No, I was going to say, yeah, you're absolutely right. We call it the forgotten obligation, because it's something that just, one single article that applies exclusively to companies outside of Europe. So it's been forgotten. And the reason I think for that is that all of these guidelines that came out on GDPR, implementation and compliance were obviously geared towards European companies, because it's a European regulation. And so people kind of forget that it applies extraterritorially, so outside of Europe. And the fact that this obligation only applies to non-EU companies, it's not a box that you need to check on those to-do lists for GDPR compliance, because those lists are usually made for European companies and they don't need to appoint a rep. So it comes as a big surprise to a lot of non-EU companies when you tell them that after a couple of years that they may have done everything to become GDPR compliant and think they are, but this is like a major obligation that they haven't complied with because they don't know of it.
Yeah, exactly. I think we find the same thing in practice. And so I think, question 2 really asks that question directly, but maybe I can have you expand on it a little bit. Is it a true statement that any company that is required to comply with GDPR sort of on an extraterritorial basis, would that organization need to have a representative under Article 27?
I would say most of them do, but there are a few exceptions. So Article 27 will only apply if you fall, the non-EU company falls under the scope of the GDPR and does not have an establishment in the EU. So if they have an establishment, that's the point of contact for European people, to exercise their rights, or the data protection authority. So the EU rep is only there if the company does not have an establishment. Now, what constitutes an establishment? Well, there's no real definition, but it's really has to have, it's a presence that the company has in Europe that has a direct link to the activities, the processing activities of personal data, of EU personal data. So it could even be like a sales agent, or something that really has a link, but that doesn't have to be as important as the subsidiary or branch or something like that. So if the company has an establishment in Europe, no need to appoint a rep. And then if you don't have an establishment in Europe, you have to see, okay, do you fall under the description of the conditions for appointing a rep? So if you offer goods or services to people in Europe, even for free, you fall under the obligation to appoint a rep. Or if you monitor the behavior of people in Europe, you also have to appoint a rep. And that means that monitoring is, for example, the use of cookies on websites. So, because IP addresses are considered as personal data. So that's pretty large. So, but then, it's really an analysis on a case-by-case basis, because just having a website that's available to people in Europe is not sufficient. You have to show that the company actually has the intention of targeting or selling or offering products. But then there's also the indirect application of the GDPR if the company in the States, for example, is a processor, as opposed to being a controller. So processor is an entity that follows the instructions, that acts only under the instructions of a client, for example. And if they do that and the client is in Europe, well, they will have to apply GDPR by virtue of the contract that the EU entity has to put in place, because all EU entities have to be GDPR compliant, and they can only work with companies outside of Europe that are also GDPR compliant, or that offer the sufficient guarantees of protecting the EU personal data to the same extent that EU companies do. So if it doesn't apply directly to your company because you don't fall under certain conditions, it will apply to you indirectly by virtue of the contract that you're going to have to sign with the EU company. Now, the exceptions to appointing the EU rep, as we said, was if you have an establishment, and also there are a second set of exceptions, but these are cumulative. So if you only occasionally process personal data, which doesn't in practice, we've never seen that being applied. So low volumes, that's another myth here, is that low volumes do not equal occasional data. So if your activities are, what you're processing is part of your core activities or just your general activities, but you have a little bit of EU data, you still fall under the GDPR. So first exception is if it's occasional processing. Second one is if the processing is only, does not involve processing on a large scale of sensitive data, and if the processing is not likely to cause a risk to the rights and freedoms of individuals in Europe. So very few companies can benefit from these exceptions. So I would say that probably 98% of companies that are in the US that fall under the GDPR and that do not have an establishment in the EU have to appoint an EU rep.
Yeah, I think it's a pretty broad net that captures most of the entities you discussed. Well, I guess one question maybe you can clarify is if you were just a processor, for example, located in the United States, servicing a controller that's based in Europe, for example, would you need a local representative as a processor as well?
Yes, definitely. It also applies to processors. And that again is by virtue of the fact that you fall directly or indirectly under the GDPR. But the whole point is that you're processing the personal data, so you do need a rep. But your obligations are less than that of a controller. So if you get a data subject request, for example, normally you'll have to forward that onto your controller, and it's the controller's responsibility to make sure that they fulfill that request. However, some contracts will include provisions where the controller delegates that obligation to the processor. So the processor is responsible for answering those those DSARs. So in any event, whatever the contract says, the GDPR clearly states that the obligation applies to both the controller and the processor.
Yeah, that's very interesting, and I think something that a lot of companies should note if they haven't already, that even if they're only acting as a processor, which many companies do, especially companies in the online space or technology space, they're probably subject to this obligation. So let me ask you now, I think, sort of specifically about what functions does the local representative actually perform for the company or the organization?
Mm-hmm. So, as I said, we're the point of contact between what's happening in Europe and what's happening in the States in terms of GDPR and processing of EU data. So there are three main obligations that are provided for in the GDPR that the rep has to do. So the first one is to answer or be the point of contact for data subjects. So individuals in the EU who want to exercise their rights under the GDPR, they contact us. So typically what happens is that the US company who designates the EU rep will put in their privacy policy who their EU rep is and the contact details of that rep. And so a data subject, an individual in the EU, can choose to contact the company directly or choose to contact the EU rep. So if we get a request, for example, then we forward it to our client. And we could only act under the instructions of our client because we act under a mandate agreement. So we can't take any initiatives on our end. So we talk to the client, we see, how do they want to respond to this? Do we check the identity of the data subject? And then we take this back and forth until the file is closed. That's what we do at EDPO. But the GDPR says that a rep only has the obligation to forward the information to the client, but we have decided that we want to be involved in the whole process. But some clients decide that they want to do that. So it's really, on a client per client basis that we determine how far we take this obligation. So the first thing is DSARS. The second thing is to be the point of contact for data protection authorities. So if there's a complaint or they want some additional information about the US company, they can contact us instead of the company. And the third thing is that we have to keep a copy of the Article 30 Register of Processing Activities. So this is something also that's a little bit less known, is that when you fall under the scope of the GDPR, you have an obligation to document your processing activities. So you put all these activities into a register, and the register can simply be, an Excel document where you put in all the required information that's stipulated in Article 30 of the GDPR. So we have to keep a copy of that. So those are the three main tasks. And on top of that, at EDPO, we also do data breach notifications. There's a debate as to whether a non-EU company, so a US company that would have a data breach, who do they need to notify in Europe, which data protection authorities? And there's certain people think that you only have to notify the data protection authority of the country in which your representative is located. So in our case would be Belgium. But the majority of people believe that the US companies, and this has been confirmed to me verbally by heads of different data protection authorities, that companies would have to notify the data breaches to all 47 data protection authorities in Europe. Unless, the data breach only concerns people in certain member states, then you would only notify in those member states. And of course, to make things a bit more challenging, the process of notifying data breaches is not harmonized. So all the data protection authorities all have their own specific procedures and documents on how to notify, and it has to be done in most cases in the national language. So we've mapped out all of these different procedures and we've translated all the documents into English. So, and we consolidated all the questions onto a platform to help our companies get a head start, because you have 72 hours from the moment that you discover the breach to notify the authorities. So it could be quite challenging to do. So we're there basically to really be, in the middle and to help our clients kind of sort things out and be there to answer all the questions related to GDPR from the European side.
Yeah, no, it's a significant obligation, and obviously the core function is I think, as you described, is basically a liaison. But there's all these other functions that are, I think, as you've alluded to, maybe best handled within the region and in a local capacity. And so I think that's a valuable service that companies should really consider, whether or not they have the capacity or the desire to try to shoulder that obligation themselves, or whether they're turning to a service provider such as EDPO is going to help them be compliant and also be sort of manage their other responsibilities better, because they're not worrying about these additional things that are less close to home, I should say. So I know you touched on this earlier, Jane, but I think people confuse the local representative and the quote unquote being established in the EU. And I think the confusion sometimes is that some companies don't consider themselves EU businesses in the sense that they don't have an affiliate office there or an EU headquarters or something like that. Can you maybe just sort of delineate, what is a company that is established versus, one that does need a local representative because they're not established?
Mm-hmm. Yeah, it's, as I said earlier, it's really tricky because there's no definition of this, and it's really on a case-by-case basis that you have to see if it applies or not. So you kind of have to look at what is the link between your activities in the US and what you're doing in the EU. So, if you have headquarters there, you have a company set up, it's obvious that you have an establishment there. If you have a branch, same thing. But it gets trickier when you think about, I just have salespeople there, or I just have an office or people that I kind of, doing market studies or, some other type of involvement in Europe. Well, how is that to be defined? And is it, just the definition of the GDPR, not the definition, but the concept, the view of establishment under the GDPR? Or do you have to extend that to, the tax or fiscal implications of having an establishment, which is a whole other definition. So there are some authors who think that just, simple sales agents in Europe is enough to qualify as an establishment, but you have to go a bit further than that, and that's what the guidelines of the European Data Protection Board. So that's like the entity that the organization in Europe that regroups all of the different data protection authorities in Europe, and they establish guidelines. And in those guidelines, they say that you have to really check and see if the activities of the company in the US compared to the activities that are performed in Europe are inextricably linked. And if there's personal data involved, because if the person, for example, in clinical trials, you can have a presence, you have an obligation under one of the directives to have also a representative in Europe. That representative is sometimes there only to have an address where you can send a bailiff, for example. Well, is that inextricably linked to your activities? You have to really see, in real facts, what is the link between the EU data and the processing and the company. So I'm sorry, I can't be much clearer than that, but it's not much clearer than that, actually. So it's really a factual thing that you have to look into. And the local representative, by appointing EDPO or another EU representative, that needs to be cleared also, is that doesn't give you or provide you with an establishment in the EU. So that's been really made clear. So having a local representative is not establishing an establishment. If that makes sense.
I think that's a hugely, and it's a hugely important point. I think it's something that I've seen many companies conflate, either, believing that, their local representative establishes them in the EU, or that, that they're not established in the EU based on their activities. And you're right, it's a nuanced analysis. I think, the general thought has been, if you have boots on the ground, meaning employees employed within the EU, physically within the EU, more likely than not, you're going to be quote unquote established there. And but you're right, it depends on a number of circumstances, and there are obviously caveats where you have to undertake sort of a fact-specific analysis to see whether you are or not. But if in either case, if a company isn't established, then the need for a local representative arises, and I think that's what companies should really take away. Okay, so question 5 is, really getting at the risks. So what kind of risks do organizations face, for failing to comply with Article 27 and I suppose GDPR more generally?
Yeah, well, for Article 27, it's quite clear. So when you've established that you have the obligation to appoint an EU rep and you don't, it's a clear breach of the GDPR. And there's a specific article in the GDPR that says that failure to appoint a representative under Article 27, when you had the obligation to do so, is subject to a fine of 10 million euros or 2% of your worldwide turnover. And the amount that, some people say, okay, 2%, it doesn't matter. We'll never get to that, but it's the highest amount that is retained, excuse me, that is retained by the authorities. So it's no laughing matter, and it's a serious sanction. And you have to remember also that's a specific sanction for the representative, but there are more general sanctions for breach of GDPR, and that go, to having investigations performed by the authorities, and they can even, block your site, block traffic for EU people. So that means, and reputational damages. So if they decide that they completely block your site, that may be more detrimental to your business than actually a fine, which would probably, the 10 million and the 2% is the highest fines, but we've not seen those yet. So I wouldn't be so afraid of the fines at this point in time, but we're seeing that there are tons of fines coming in, and the authorities are getting much more active now. And so it's definitely something to be very cautious about.
Yeah, and I would say, people need to remember GDPR is only really, 2 years old. Obviously, it had previous incarnations, but enforcement, at least from our perspective and what we've seen, is that it's increasing, and not for most companies, small and mid-sized businesses, a $10 million 2% fine is going to be a significant penalty for them to pay for failing to comply with this requirement. And I would also suggest that if a company is missing this obligation, chances are there are other compliance gaps in their compliance program, because this is one that, a detailed review of a company's obligations should reveal that this is a necessity. And so if they're missing this, they're probably missing other items as well. So yeah. I think, there's certainly reason to want to comply.
And this is one that's quite obvious, actually, because, it's supposed to be in your privacy policy. So people in Europe have really developed this kind of reflex to go check a company's privacy policy. So they quickly see if the company is compliant with GDPR or not. So it has to mention, the requirements that has to be there under the GDPR. And they check and they see, well, this company is outside of the EU, and they seem to be doing all this processing because that's in their privacy policy, but they don't have an EU rep. So it's right there, and it's it's the first client or customer or data protection authority facing information, and it's on your website, or it's not on your website because you haven't appointed an EU rep. So it's a shame, because you can, as I was mentioning at the beginning of the interview, you can have put in place all the necessary organizational measures and GDPR measures to comply with. But if you forget to appoint a rep and it's not in your privacy policy, this is the first thing that people are going to see when they're going to your website. So it's unfortunate, because you will have, done all that, but you're showing the outside world that maybe you're not that compliant because you forgot this obligation.
No, that is a great point, and it's a great practice tip, because you're right. If anyone is checking and just doing a cursory review to see whether or not you are compliant, this is a huge red flag if they don't have this, and it's right there, publicly facing on their privacy policy. So that's a really great point. You can probably save yourself a lot of trouble just by having this on there, because at least it demonstrates that you've at least thought through this obligation and have taken some action on it. And even if you're worried about your compliance in other areas, this is a good way to sort of maybe ward off some initial scrutiny that might otherwise come your way.
Yeah, absolutely.
So last question here, Jane, which is, there's been a lot of different things happening, recently, especially with the Schrems 2 decision. I guess from your perspective, since you're involved very significantly in this area, maybe can you just give us what your thoughts are? What are the big changes, if any, that you see in the GDPR landscape?
Well, I think, as you just mentioned, William, the biggest thing right now is this privacy shield being invalidated, and that's having a humongous impact here. And we see on both sides. So we have, quite a number of US clients, and we're getting a lot of requests from data subjects in the EU writing to us and saying, okay, this company, I'm working with them, and what's going to happen because they're on the privacy shield list, can I still use them? And all companies here are quite worried because, we don't quite know what to do. Everybody is pretty much using a whole bunch of American software and platforms and things like that, and apps. And it's hard to, from one day to the next, because there's no transition period, that you just kind of can't do that anymore unless you fall under certain exemptions, sorry. But they don't apply that much in all cases. So really, really challenging times, and we're waiting to see what the European Commission is going to do. But in the meantime, Max Schrems and his organization have not lost time in trying to have this enforced, because they've just filed 101 complaints, I think it was a couple of weeks ago, concerning companies that have not yet stopped the transfers to the US based on the Schrems 2 decision. So they're really going, full speed ahead with this. And you have, for example, one of the German data protection authorities last week who came out with guidelines saying that they're going to closely monitor all companies that fall under their jurisdiction to see, in every case, if the companies have done kind of like a process of evaluating if they can find European alternatives to the US platforms or apps or whatever that, that they're using. And if there are European alternatives, then they will be sanctions for not having used those instead of US products. So this is going to be, we're talking about, trillions of dollars of trade, and the impact is just humongous. So it's kind of chaotic right now.
Yeah, I know, and I think we've had a number of clients that have been impacted, and I think just the biggest challenge in trying to advise them is we don't have really good guidance yet on what the obligations are, and so from a compliance and risk management perspective, we obviously have some inclination that we can do certain things that I think are going to make them less of a target or help mitigate some of the risks that are addressed that required to be addressed, but there's no silver bullet here. There's no perfect solution, and so it's tough to be in an advisory capacity when you can't offer that that solution that we can say with a high degree of certainty that it's going to shield them. And so yeah, I think you're absolutely right about that.
Yeah, so it's kind of like wait and see approach, and take appropriate measures in the meantime to kind of minimize the impact, minimize the risk. There's certain things that can be put in place, and I'm sure that you'll be helping your clients out with that, William. And if you or anybody else wants to discuss that, I'm happy also to jump on a call and keep you guys up to date on what's happening from the EU side.
Absolutely, all the information helps at this point for sure. So Jane, again, I want to thank you for your time today and for answering our questions. I think the information will be, as I mentioned, really helpful to a lot of companies and organizations that are looking to address their compliance obligations under GDPR. And so if you want to learn more about Relic Law's multidisciplinary privacy and cybersecurity practice, you can visit our website at reliclawpllc.com. And if you'd like to reach Jane or learn more about EDPO's local representative services, you can reach her at her contact information there or at edpo.com. All right, thank you very much, and we'll see you next time.